Well, good morning and welcome to this webinar sponsored by Ministry Pacific. I'm Roy Harriman, your host, and in just a moment, we'll begin a presentation on workers' compensation for houses of worship and faith-based organizations. This webinar is a free resource of Ministry Pacific Insurance Services, and we provide complimentary education to everyone, whether they're clients or not, because we truly want you to succeed. We're insurance brokers, and that means we're free to research the market and find the coverage that is best for you. And we're here to serve. So please take us up on our offer of a free consultation at ministrypacific.com. Workers' compensation for houses of worship and faith-based organizations. We're grateful to have two experts on this topic, Justin Stringer and Brian Gleason. Both are senior risk managers for Guide One Insurance, and they have combined decades of experience in insurance and risk management for faith-based organizations. Welcome, gentlemen.
Good morning.
Good morning. Thanks for having us.
Yes, great to have you. And I am going to hand you the keys, and we will let you begin.
I'll kick us off. So thank you, Roy. Thank you, Ministry Pacific, for having us this morning. Appreciate you all joining on the call this morning. And you guys have a lot of competing time priorities. One cover real quick, the relationship between Ministry Pacific and Guide One. So Ministry Pacific is the broker that brings you to Guide One needing insurance, and Guide One is the insurance carrier. So in that unfortunate situation where you have a compensable claim, that check will be signed by Guide One instead of Ministry Pacific. So kind of helps understand the relationship between us and Roy's team. One of the specialties, or a few of the specialties of Guide One, and why Roy and Ministry Pacific brought you all to Guide One, is because we're a niche-based organization, and few of our niches is religious organizations, houses of worship, and nonprofit human services, which also includes education. So think your daycares, your preschools, and other childcare organizations, which, from what I understand, meets a lot of the attendees this morning. So thank you for Roy and team for bringing us to Guide One. And real quickly, I'll get you over to our subject matter expert on casualty related, and that's Brian Gleason. So Brian's got, as Roy said, decades of experience working in all things casualty, occupational health and safety, sexual abuse prevention, emergency management, and a few other topics as well. So with that, Brian, the floor is yours.
Thanks, Justin. Justin and I have decades of experience working with organizations, primarily on casualty, both property and casualty issues. My specialty is casualty, which includes workers' compensation. Before we get going too far, this is the standard disclaimer that says I'm not a lawyer, and I'm definitely not your lawyer. If you do have questions, concerns, please consult an attorney in your jurisdiction for further information. Probably should start with what is workers' comp. Workers' comp is a state-mandated system of insurance that guarantees that your employees get the medical care they need and compensation for any lost time at work. It's a no-fault system, meaning that we don't go after the employer, we don't go after the employee. It's just a way to get their medical bills paid and get their time paid if they get injured on the job. Pretty straightforward. It does also protect the employer in that this is the only remedy for workplace injuries. You can't be sued unless there's just absolute gross negligence for those workplace injuries. So, like we said, it's provide medical expenses, income protection. And again, there are some anti-retaliation statutes in there as well, so that the employee can't file a claim for any other benefits. So unlike private citizen who may be on your facility who can sue you for their injuries, this is the remedy for employees. So basically, they have an injury, the insurance carrier pays their medical bills. If they're off of work, pays their salary so that they can get them healthy and back to work. So like I said, benefits their employees, making sure that they get everything they need, all that medical information, they get healthy and whole again. The benefit to the employer is that they can't seek damages through another way. So we get them back healthy without the employer being on the hook for a lot of medical bills. It also helps control the cost for the employer in that their workers' compensation premiums cover all those medical costs and things, so that you don't get the bill for $150,000 for a terrible injury to an employee. It's metered out through workers' compensation premiums. So who has to be covered? There's nuances in each state, about some of the details in specific cases, but the basics are every employee, whether they're part-time, seasonal, if they are your employee, you have to cover them for workers' compensation. Independent contractors, in most cases, are not covered for workers' compensation. And again, there are nuances around that and the specifics in each jurisdiction about what exactly an independent contractor is. We'll leave that to the accountants and attorneys to settle out, but there are details around that as well. So here's why it matters. Employees get injured, unfortunately, not in enormous rates, but enough that it is a problem. In 2023, 2.6 million non-fatal workplace injuries, meaning that 2.6 million employees had some form of injury on the job that kept them from going back to work or caused them to need medical attention. If you don't have workers' compensation, the employer has some financial risk there. The employee has no way to pay their medical bills, hence the workers' compensation system. It's also required by law in most places. So it's not something you can get out of for your employees. So like we talked about, what it covers. It's going to cover medical expenses. And that's doctor visits, surgery, rehab, physical therapy, a wide variety of medical treatment that could entail. In some cases, it can be both physical, it can be behavioral health or mental health as well. It's going to also pay lost wages for their time off. If they're off for any length of time, the workers' compensation kicks in and pays their salary, subject to some taxes and things, but it's going to pay the bulk of their salary. So they are essentially made whole for the time off from work. If there's a permanent disability, it's going to pay them for that disability. Get that all settled as well. If the employee can't return to their previous job because of a workplace injury, it's also going to pay out what we call vocational rehab. It's going to pay them for some training to get them into a new line of work so that they can continue to earn. And in the terribly unfortunate case where there's death benefits, where an employee is deceased because of a workplace injury, there are payments for the employee's family, much like life insurance. So all of that is part of workers' compensation. The injury doesn't need to be a specific one-time injury. It can be something like a cumulative trauma injury for, like carpal tunnel or neck and back problems from repetitive motion. Some things like hearing loss. In some jurisdictions, stress and mental health issues can be a part of that as well. It does vary by jurisdiction. Some states have a more generous program around that than others. But all of those are examples of things that may be workplace injuries or illness. And when we say illness, there are some things it doesn't cover when your employee gets the flu because they might have been exposed to someone. There were some exceptions for COVID specifically. California, for example, had some very specific statutes around what exposure to COVID was covered. For example, if you were in a healthcare situation and were exposed, it was covered. If you were exposed, as a part of an office environment, it was not. If there is a specific situation, for example, if as part of their job duties, they're exposed to mold or, excuse me, other toxins in the workplace, that could be covered potentially. Things it doesn't cover. And again, these vary a little bit by state statute, but in general, it's only going to cover workplace injuries. If you're not on the job, it's not going to pay for your injury. By statute, it does not cover self-inflicted injuries. If the employee intentionally injures themselves, that's excluded from workers' compensation. That's a whole separate issue. It does not cover employee intoxication, misconduct, what we call horseplay. If that employee is working outside of the clear safety guidelines, that will in most cases be denied as a claim, not paid because they were not working within your guidelines. Does not cover injuries suffered while committing a crime. And again, violations of company policy. If you have clear safety guidelines and they clearly violated those, there will be an investigation. In all likelihood, those will not be covered. So what's the employer's responsibility? Well, the first piece is you got to have workers' compensation coverage. And like we talked about, Ministry Pacific can help you obtain that. They can help you set that all up. There are some statutory notices you have to provide to your employees. In some cases, you may work within what we call a member provider network so that your medical providers are all set up ahead of time. So your employees only work within a group of doctors that you've identified. That has to be noticed to employees. You got to report claims to your insurance carrier so that they can pay those bills. In some cases, there are some requirements to also report them to a state agency. For example, in California, it's Cal OSHA. In other states, it might be an occupational safety and health organization of some type. If there are workers' comp insurance claims, by statute, you can't retaliate against the employee just for filing insurance claim. And again, you got to keep some records around this. Not terribly onerous, but there are some things you do need to keep track of there. So here's the simple version of how this all works. So the employee gets injured at work. You're going to file a report with your carrier. Your report collects some information from the employee. The employer is going to fill out some information. Each state has their own forms that you'll need to complete. Submit that information to the insurance company. The insurance company evaluates that and pays out benefits, including medical payments, compensation, all of that. As the employee gets better, the employee returns to work, or in the case they can't return to work, they're transitioned to a different type of job. So let's get into the details, how we work through all of that. Obviously, if the employee is injured, you immediately want to provide first aid to the best of your ability, within your abilities and guidelines. Requires emergency medical treatment. Make sure you get 911 called, get that there. Once you get that employee stable, you need to obtain the facts from the employee about the accident. So what happened? Collect those details. You need to provide notice to the employee of their workers' compensation coverage. Make sure they know that they have the ability to file a claim. And then you need, as the employer, need to file that workers' compensation claim. Each carrier is going to have some nuances around it, but essentially you're going to complete some forms and send those into the insurance company. Typically, rather quickly. For example, in most states, you're going to want to do that within 24 to 48 hours. The sooner you do that, the better. We'll talk about why. If you can report that claim within 2 weeks, it gets more expensive, 18% more costly than it's reported in the first week. If you wait till 3 or 4 weeks, it becomes more challenging for the insurance company to manage that claim, and the costs get higher. If you get to the 4th and 5th week, we're getting to substantially higher costs for that insurance company to manage that claim. And here's why. In most states, the insurance company has 90 days in which to investigate that. There may be situations where you think the claim might not be accurate. There's nuances around that, but if the employee was involved in horseplay, you don't think the accident actually happened. If it's around a mental stress claim, there are some issues around that and some medical information needs provided to verify that it really was work related. The sooner the insurance company has all that information, the sooner they can investigate and either accept or deny the claim, making sure that you're actually liable for all that. If you wait too long, the insurance company doesn't have the ability to do that, and you're on the hook for a claim that may or may not be valid. So keep that in mind. You want to get that processed quickly. What do you do when it happens? So after we've gotten the employee medical treatment, you got their information off of the insurance carrier. You want to investigate and document the accident as soon as possible. You're going to get statements from others around you, take photos. If there's equipment involved, make sure you take photos of the equipment, recreate the accident if you can, so that everything's documented, you know exactly what happened. And then you want to kind of review it and figure out if there are things you could have done to prevent the accident. So if it's they fell off a ladder, was the ladder stable? Was it a safe ladder to start with? Should there have been a second individual there to hold the ladder? All those things need to be documented, of course. So here's a real world example. An employee slips and falls and spills water. Or here's another real life claims example. In a daycare situation, feeding students, and somebody dropped a paper plate on the ground, and another individual stepped on that paper plate, slipped and fell, resulting in substantial costs. Workers' comp pays with surgery, hospital bills. They were out for 8 weeks, 8 weeks of lost wages. The employer doesn't get a lawsuit. The employee gets proper care. It's all taken care of within the framework of workers' compensation. You have a better idea of what's going on. So we talked about compensation. That employee, if they're off work, this is how that's paid out. We got two types, temporary and permanent. Temporary total disability means the employee is not able to work, meaning that they can't come to work, they can't do most of their job. So the insurance program is going to pay the bulk of their salary, basically enough for them to live on what they would normally receive after taxes, because workers' compensation payments are not taxable. So they're going to get that income. Temporary partial disability is for when that individual is under medical treatment. They can return to work, but only for certain hours a day, or 4 hours a day instead of 8 hours a day, or something like that. They're going to receive partial payment for the portion that they weren't able to work day. Or if they would normally receive $22 an hour as a preschool teacher, but you had to bring them back as a receptionist, which only pays $16 an hour, that temporary partial disability would pay the difference in that salary. The second is what we call permanent total disability. This is what happens when that employee is injured to the point where they can no longer continue to do the type of work they've been doing. They are now totally disabled and will be living outside of the employment system for the rest of their lives. They'll receive a settlement negotiated by the insurance company that takes care of all that. Usually determined in most cases through a state-appointed system. They'll be reviewed by a panel of doctors, fined by the state in most cases, to determine exactly how much disability there is, how that's going to impact the rest of their lives. There's a formula that takes into account their current age and what the expected working time would be. So it's going to be a lot more money if it's a 26-year-old employee than if it's a 56-year-old employee, because it takes into account how much more time they would have working, and they'll settle on an amount that's paid out. Permanent partial disability might mean that they slipped and fell and did some pretty significant damage to their knee. They can continue to work, but not in the same way, and it's going to diminish their wage earning ability. They're not going to be able to work for as long or as well. And again, that same kind of formula applies at how long that's going to impact them, and they'll receive a settlement for that as well. The state has a statute based on specific how you're disabled. Is a limb, is an eye, and this is where it gets a little bit creative. You'll see reports from your insurance company where they list a whole bunch of body parts. And they'll add and subtract body parts to the claim based on what the doctors tell them, because the claim may originally come in, particularly if the employee is attorney represented, they will likely claim a whole number of body parts in the claim. And then it's up to the insurance adjuster to work through in conjunction with the medical staff and determine exactly which body parts are truly impacted, because they may list things that may or may not actually be impaired. Based on all of that calculation, they'll receive a payment. Usually pain and suffering in and of itself is not part of the workers' compensation system. It's just the true medical costs that diminish the earning capacity of that individual. So the bottom line, how do we control costs? Because ultimately, your ability to control costs is going to impact your workers' compensation premium. Because your premium is based on a number of factors. It can be based on the industry you're in, along with your loss history. Those things are put into an elaborate calculation by your state workers' compensation board, and it creates what's called your experience modification. So based on that number, typically a 100 experience mod is average for your industry. If you have a 78, that means you've done better than the average organization in your industry at reducing costs. And then what your ultimate financial premium is then multiplied by 0.78. You pay 78% of that premium as your final workers' compensation premium cost. If, however, and it's called a credit mod, if, however, based on your loss history, your losses generate out to a 1.68 experience modification, meaning you're 68% higher than the average in your industry, that's what's called a debit mod, meaning that we're going to take that financial premium, multiply it by 1.68, meaning you pay essentially a 68% penalty because you haven't been preventing claims and controlling costs in your organization. So how do we control those costs? We're going to promote workplace safety, make sure we've got workplace safety programs. We're reminding employees to work safely. They've got appropriate tools, guidelines, direction, supervision. We're going to create a return to work program because the sooner we can get an individual back to work, the lower the costs are. It keeps them in a healthy frame of mind. It lowers the costs of the compensation that are paid by the workers' compensation system while they're out. It also has them back at work with their coworkers doing something productive rather than sitting at home watching all those commercials on TV about have you been injured with every attorney who wants to represent them. Report claims promptly to help prevent fraud. We've talked about that lag time issue. You want to make sure you get claims reported quickly, and then work with your insured to manage those claims. Work with them. You communicate regularly. When the doctor says they're ready to return to work, get them back to work. When you need to modify their job a little bit, work with the insurance company to do that as best you're able. The better you communicate with your insurance carrier, the better they're going to be able to help you manage the costs associated with that claim. So legal requirements. Each jurisdiction has some different legal requirements. Most places mandate it for full-time and part-time employees, and there are some very significant penalties for non-compliance. This generally follows under OSHA, or in California, be Cal OSHA. There's either a federal or a state agency that oversees this. Failure to comply, provide appropriate notices, can rack up some pretty substantial fines. I worked with one organization recently that did not handle workplace injury appropriately, ended up with a $10,000 a day fine for their inability to manage claims well. You can imagine that adds up very quickly, particularly if that state agency finds negligence on your part. We all understand that there are things you can control and things you can't. Failure to complete paperwork is generally not seen as negligent. It'll have some relatively minor fines. But if there's, blatant disregard for safety programs or failure to notice, those fines rack up very quickly and get very expensive. So we talked about workplace injuries in the course of employment, which usually means they're at your workplace doing their job and they get hurt. The challenge is, in this day and age, not all of our employees only work at your workplace. They come and go. They go between work sites, things like that. So the general rule, the employee is not covered for their commute, but there's an exception if you're on the employer's premises. So if they slip and fall in your parking lot while they're coming into work, that is a workers' comp claim. If you have them run errands on their way to work, they're now on your clock and they're your responsibility under workers' comp. So here's an example. Employee is in a car accident during her commute to work. She stopped at the office supply store to purchase some things for the employer. She's now on the clock. She slips and falls in the parking lot. She's now got a workers' compensation claim. Keep that in mind when you're assigning work to employees, and have them coming and going to work and doing work on the way. Same thing applies if you're going between work sites. If you have a daycare with multiple locations, if they're commuting between those locations, they are on your clock and potentially covered by workers' compensation. Here's another nuanced example. Employees bitten by a dog while taking a walk during his lunch break. Because he's on his lunch break and not actually working, he's clocked out, not on your premises, it's not a workers' comp claim. It's going to be denied if it's filed. So that, there are some nuances here, and typically we're going to leave it to that adjuster. They're going to work with you to determine if it's compensable. But keep in mind, just because they're not on the clock, on your premises, having clocked in, etc., it may still be compensable. When you have an employee who's off of work for a workplace injury, you also need to coordinate all of this compensability things we talked about, the temporary disability, permanent disability, all those things also have to be then consolidated in with ADA and FMLA. So if you got an employee who has to be off, your HR individual, whoever is responsible for HR at your organization, is going to have to work between the insurance carrier and your own internal processes around family medical leave and the ADA, Americans with Disabilities Act. Meaning that if that employee is injured, if they've got some permanent disability, you may be required under the ADA to make some accommodations to bring them back to work if that's within your ability. Things like if they now need to work in a wheelchair, do they have access to get in the building? Do they need a different type of chair to do their work because their doctor recommended, they say, or they need to stand instead of sit, or sit instead of stand. Things like that may be required under the ADA because they now are a disabled individual. So keep that in mind. Again, it does get a little bit complicated, but that's all part of the process. So we talked about return to work, and we really encourage you to develop a robust return to work program. So the sooner we get employees back to work, the healthier they are in the long run, and the better the morale works. It reduces recovery time and minimizes workers' compensation costs. So make sure there is a structured program that gets that employee back to work as quickly as possible. It's going to reduce workers' comp claims costs if you as an employer. You're going to maintain productivity because you're already trained and reliable employee is back to work as quickly as possible. Reduces turnover costs. For that employee, it provides stability, income and benefits. They get the morale consistent. And the longer they're out of work, the higher the risk of long-term disability. So we want to get them back as quickly as possible. It keeps those professional skills sharp. We don't want them camping out at home on the couch for too long, because ultimately that just ends up being more challenging in the long run. So in order to make a return to work program work, there are some elements you really do need to have. A written policy, you need to have clear guidelines on when it's applicable, what you can do and can't do. There are things you can do to accommodate, things you can't do. And the law does not ask you to have them come in just to count paper clips. That's not meaningful work. But if there is something else they can do to accommodate the injury, you need to provide guidelines on what that is. Somebody's got to be responsible to coordinate that work, whether it's an HR function or a supervisor. And in order to do it effectively, you really do need to have job descriptions and clear understanding, because that doctor is going to need to know what the physical demands are of the job before they can effectively return them to work. So that employee can't return to work until they've been released by the doctor. The doctor's not going to release them until they know what the job duties are, the physical demands, and whether or not they believe that individual can do those things. We're talking about transitional duties. These are temporary tasks. We talked about earlier, if you've got a childcare operation and they're normally a teacher in a classroom, but because their injuries can't do that, but you've got them working as a receptionist. You can do that within the restrictions. They can sit in a chair, answer phones, greet people. And again, you want to work regularly with the doctor, communicate the disabilities, because they will likely change. As they begin to heal, they typically get fewer restrictions, but you want to manage the work within those restrictions. And you want to make sure you're communicating regularly with the employee. And it's not just the details of their medical work, but empathy, support. Make sure they understand that you do want them back, that you support them, that you're going to get them back to their work as quickly as possible, that they are still a part of the team. So this is kind of what that flow looks like. After the injury occurs, you get a medical treatment assessment, submit the claim. You're going to work with the doctor on work restrictions. You're going to provide that job description that lists the physical demands. The doctor is going to review those, make notes, and determine what portions of that job they can and can't do. And then you work together to develop a return to work plan, with transition or modified duty. It might mean that they can do their work, but only for 4 hours a day. Or the work they would normally do standing, they need to do sitting, or something like that. You develop a plan, write it all out, so everybody has a clear understanding about what's required, what's expected, for how long. Monitor that progress. Again, working with the doctor, and then ultimately either return them to full duty or create a permanent accommodation based on their ultimate treatment plan and what the doctor recommends. So here's some examples of transitional duties, things that they would normally may not be part of the regular job duty, but things we can have them do temporarily that may require less physical exertion, or not, a different type of physical exertion that doesn't exacerbate their injury. So administrative support, things like keeping track of paperwork, filing, things like that. Safety inspections. One of my early jobs was working in a warehouse. We had an individual who was injured in an industrial accident. One of his modified duties temporarily, because he couldn't do lifting or drive forklift, was to actually develop a safety plan around forklift safety. So he spent 2 weeks of his time off developing safety plans and inspections. So inventory tracking, you got things you need to detail, data entry, customer follow-ups. If you're running a childcare organization, calling parents and making sure that payments are up to date, making sure people are signed up for the next term. If you're in a house of worship, it may be congregant follow-up, sending birthday cards to congregants, or following up on registration for an event, things like that may not happen normally, but are a legitimate part of the house of worship operations, things that can be done without exacerbating that injury. Training and mentoring, they may not be able to work doing their normal duties, but they can supervise someone who does those duties. Their long-term experience provides them the ability to provide guidance and direction to somebody who may not be less experienced. So there's just some ideas. These are things you want to keep in mind, ideas around what they could be doing. The more flexible, the better. And again, we talked about you got to work within some of these federal and state guidelines, OSHA, workers' comp laws, family medical leave, ADA. So keep all of that in mind. And we do recommend having some resource that you can consult with around some of this, because it does get complicated. So we talked about this return to work program. How do you know if it's been successful? Well, ultimately, you want to see fewer lost work days. Employees are off of work for less time. You should see some cost savings ultimately. And we understand that most of these organizations don't have enough volume of claims to really be able to compare, but give you some idea around that. Talk to employees. Most employees prefer to get back to work as quickly as possible. We want to make them healthy, happy, and whole again. Reduce turnover. Again, the longer that individual is out of work, the less likely they are to actually return to work. So we want to get them back as soon as possible. And typically we want to see them within 30, 60, 90 days, depending on the severity of their injury. We start getting beyond 90 days, the likelihood of them returning gets slim. So there's some common challenges. A lot of organizations, really struggle with lack of modified work. Well, what do we have to do? We would encourage you ahead of time to develop some tasks. Get out a notepad and make a list of some things that could be done. Projects that you've been putting off because you don't have somebody to do that. Keep that list going in advance so that there are some things you can do. I'm talking about poor communication. Make sure supervisors are trained. They understand the ability for modified work, how that's going to work. Sometimes we do see resistance from employees, particularly those that have legal representation. Sometimes they will resist because they want to stretch that claim out. We don't see it as much in faith-based organizations, but it does happen. We just need to work with them, understanding that return to work is better for them in the long run. Sometimes you will get physician pushback. And again, a lot of that is around just providing them clear, accurate job descriptions that describe what the actual physical work is. That's usually where the issue is. The physician doesn't really understand what the work involves physically. So the more information you can provide there, the better. So how do you develop that plan? Develop those internal policies. Make sure you have a clear direction on it. Identify those transitional tasks we talked about. So what things could they be doing that they don't normally do? Training managers, return to work coordinators, make sure everybody has an understanding. And then we would encourage you to launch an awareness campaign. Really make sure that employees understand ahead of time that return to work is an option. That goal is to get them healthy, happy, and whole again. And sometimes that means bringing them back to work at something less than full duty. We know we've talked about a lot of information over the last 35, 40 minutes. These are all resources from Guide 1 Insurance. We've got a glossary of terms for workers' compensation. We know we've used some jargon and some industry terms in this presentation that will help define there. We have a sample checklist for you to work through, things that you as an employer can be doing to make it a safe workplace. A sample injury and illness prevention program. Most states have some requirements around what you as an employer are required to do to create a safe workplace. This helps document those efforts. And then we talked about that modified duty return to work program. We've got a whole document around how you can help create that. So all those are provided to you free of charge, just for participating today. We appreciate you being here. We've got all those links. And then these are some other outside organizations that have resources that may be helpful for you. We know a lot of you are in the state of California. So the state of California, in many ways, is unique and has some very specific rules around workers' compensation. In fact, it's unique enough that the state of California has developed its own video around workers' compensation. I encourage you, if you're in California, to view that. NIOSH, National Institute for Occupational Safety, has some data around workers' compensation that may be helpful for you. On the federal level, Bureau of Labor Statistics has data as well that may be helpful depending on your industry. And then OSHA is the Occupational Health and Safety and Health Administration. That's the federal agency that oversees workplace safety. So there may be resources there that may be helpful as well. So again, I know we covered an awful lot, and I'm sure you've got some questions. We're happy to answer those.
Well, thank you, Brian. I will kick us off with a question I have, a topic that often comes up, really not just talking about workers' compensation, but any kind of mandate, is faith-based organizations want to know, is there a religious exemption?
On the whole, no. There is not a religious exemption. The only caveat I would put around that is, based on the structure of your faith-based organization, there may be some different definitions about who is an employee and who is your employee, particularly around things like clergy. In some cases, you may need to clarify that. In some faith traditions, the clergy are actually employees of a diocese or a regional denominational group or something like that. So you may need some clarification around that. But on the whole, no, there is not a religious exemption. They are employees of an employer within that state. They're required to be covered under the workers' compensation policy.
A lack of information is not your friend. Particularly, you caught my attention when you mentioned a $10,000 a day fine, which for, I'm sure, everyone listening here today was a startling amount. No one's like, oh yeah, we can cover that easily. So yep. If you're not sure, find out, but just in general, understand.
Absolutely.
Exemptions are not available because of religious status. And by the way, Danielle, thank you for the comment. Informative webinar. That was our goal. Brian, based on your experience, who is a good person on the team to manage this workers' compensation? Somebody's got to own it at the organization. Do you have any experience, like who can be a good person to tackle this?
Absolutely. So usually it's whoever is responsible for the HR functions of your organization. Until you get to particularly large organizations, if we get to large organizations, you might get to the point where you do have somebody specifically responsible for occupational health and safety. But for most organizations, that they're just not large enough to need that. But it's going to be the same individual who's responsible for that paperwork when you hire someone or terminate someone, who's responsible for employee benefits, those types of things. Whoever's responsible for that is probably the person you want to be responsible for this as well.
Maria has a question here. Do those in California that receive a donation or 1099 need to be covered under workers' compensation?
Many faith-based organizations pay a number of people 1099, or what we call independent contractors, things like some musicians, guest speakers, things like that. Those are not typically your employee. And again, I would encourage you to seek legal counsel and work with your accountant and some others around exactly what your state requires to be an independent contractor, because there are some nuances around that, how much control you have over the individual, things like that. But if they truly are a 1099 independent contractor, then they would not be covered under your workers' compensation policy. The expectation there is that they would have their own coverage or be responsible themselves for those injuries. And I would encourage you to build that into that contract that you have with the individual, that there's a clause in that contract that states that as a contractor, you are not covering them through your workers' compensation coverage, that they are responsible for that coverage themselves. There is a little bit of nuance in faith-based organizations, and that quite usually have volunteers who may be performing similar functions to employees. If you do not pay them in any way, if they're truly volunteers and not employees, that's not going to be covered by your workers' compensation policy. That's typically going to be covered under a medical payments line of coverage in your general liability coverage, your general liability policy in your insurance program. So just like if you had somebody slip and fall on the sidewalk, it's the same line of coverage that pays if a volunteer falls off a ladder while hanging lights for the Christmas decoration, or slices their thumb while preparing the Wednesday night meal for congregants or something like that. So yeah, that's part of why we encourage in that general liability coverage that you have an adequate medical payments line of coverage that helps cover those kinds of things.
You made a good point when you said it's always best to clarify what is the law in your locale. An issue in California is that often people who have been classified as independent contractors would in fact fall under employee status in state law. So then you have the double whammy. You misclassified someone and you did not provide workers' compensation.
Correct.
So clarity of job roles, employment status, information is your friend. Yeah. Ignorance is bliss until you are fined, right? And then then the party's over.
Absolutely. And I would encourage you, again, to talk with local legal counsel, but California particularly, and most states generally, actually, a lot of organizations pay people as independent contractors that probably really should not be. And states are cracking down on that. If you control when they show up, if you tell them how to do their job, if you provide the tools that are required for them to do their job, they are probably an employee under the law. So keep that in mind.
When we think of workers' compensation, at least I think of someone rolling up their sleeves, mopping the floor, fixing the window. What about Pastor Steve, who, like, he doesn't even break a sweat, right? Does he need to be covered?
And we find in smaller congregations, particularly, Pastor Steve may be breaking a sweat because he may be the one plunging the toilet, painting the steeple, and in fact, that's quite often where we get a lot of our workers' compensation claims, in that individuals whose background, their training might be from seminary, are doing tasks that they weren't trained to do, is outside of their experience. But yes, keep in mind that coverage also would cover them if they are traveling in their car to visit a congregant in the hospital. If they are, for your youth pastor, that might be traveling with students, taking them to camp or on an activity. All of that is covered by workers' compensation. So yes, they do have to be covered, unless if they are your employee. Going back to that one exception I described earlier, if they are truly an employee of the denomination or diocese or somebody else, then that organization would be responsible for their workers' comp coverage. But if you are cutting their paycheck, you need to be covered under workers' comp.
You did a great job, Brian, kind of outlining the different components, what is covered or not. The insurer will investigate the claim. So if an employee says that they were injured during the course of their work, but if the employer is suspicious or believes it was something like horseplay or something that shouldn't have been covered, can they say that, or does that become a legal matter?
I would encourage you in situations like that, go ahead and file the workers' comp insurance claim. Because what's going to happen is the adjuster is one of the first things you can do. The adjuster is going to contact the employee, and the adjuster is going to contact the employer, typically the employer first, and take a statement from them, get all the details, and that's the opportunity for you to describe why you think there's an issue with this claim. The adjuster is going to take all that information. Then they're going to get the information from the employee side of things. And then they're going to pull the facts out of all of that. And in some cases, they may even hire an outside investigator to determine what those facts are. For example, we insure a broad variety of organizations. We have situations occasionally where an employee will claim an injury, and we've had some situations where we hire an investigator and come to find out that that person who claimed to be incapacitated is out, body surfing, caught them on video, skateboarding, things like that. Um, and ultimately, that's workers' compensation fraud, and the insurance company will deal with that appropriately. That can actually have criminal charges filed in some cases. We don't like to go down that road, but if necessary, that's part of what the insurance company does. Because ultimately, once you've paid your insurance premiums, the responsibility lies with the carrier to pay those claims, to determine if it's compensable. And if they believe that it's fraudulent or should not be paid, they're going to do that investigation and determine that. That also allows the employer to not get caught in the middle. You can blame it on the insurance carrier, let them sort it out. That's why insurance carriers have qualified adjusters who know all the nuances of that law, what is covered and isn't covered. So ultimately, yeah, let the insurance adjuster make that determination, but you will absolutely get a chance to tell them why you think it is not an appropriate claim.
What would you say, Brian, based on your experience, what are a couple of the most common mistakes that employers make in dealing with this whole matter of workers' compensation insurance?
Obviously, the first one we see most often is that either they don't report the claim or they wait far too long to report the claim. And in some jurisdictions, far too often, we see the claim actually filed by the employee's attorney because they didn't get satisfaction quickly from the employer. They immediately found one of those, we used to call them ambulance chasers, but those personal injury attorneys who have those billboards on the side of the highway and the ads on TV, have you been hurt in a workplace accident? And that's the last thing we want to do is find out about that. If we get the claim from the attorney, that's not real helpful. That tells us that the employer was not proactive, didn't get the information. So that's the first piece, is make sure that you get that claim filed quickly, and then it's working with the adjuster and the employee to work through that. We'd also encourage, you don't need to make a statement, you don't need to accept fault for it, just get the facts and turn that over to the insurance carrier.
I'll add one thing, kind of jump in here, is putting employees in positions where they shouldn't be in. Whether they're untrained, as Brian's example, having that pastor that may just have seminary experience get up on the ladder to clean the gutters, just because it might be cheaper than getting a contractor to do it, that pastor may or may not have that experience. So you want to put your employees in a place to succeed and not put them in areas where it might be dangerous and they're not trained for. So just make sure the role matches the person and their skill set.
Our last question here is from David. He says, what are resources to use to help those of us who don't have a safety program? How do we develop one? That's a great question. Absolutely.
And one of those resources I had be in that presentation that you'll receive is a link to what we call an injury and illness prevention program. It will seem like a large, somewhat overwhelming document, but it's really pretty straightforward and lists a number of ways that you can develop a safety program. Things around, what do you require employees to do? What training do they have? What personal protective equipment do they have? Do they have the right tools? How do they go about their work? Are there places they should and shouldn't be? Things like that. So that document provides a framework to help build that.
Justin and Brian, any closing thoughts you want to make sure that everybody gets before we wind down here?
I'll just say thank you for taking the time today. We appreciate it. And really, our goal from Guide One, we're the insurance carrier. So our goal ultimately is to provide you tools and resources to keep you focused on your mission. We understand that insurance issues are not your primary responsibility. They're actually a distraction to your mission. But so we want to provide tools and resources that keep your resources focused on your mission and not tied up in litigation or insurance claims and things. So we just appreciate your time today.
Couldn't have said it better. I agree, Brian.
Insurance isn't our mission, and it can be a distraction, especially if we don't pay attention to it, right, and take our obligations seriously. Then it's really a distraction. So much less of a distraction to get the facts and put the safety program in place, make sure people are covered, classified correctly. And it's not easy, but it is part of the role of leading in an organization. So, well, at Ministry Pacific, we thank you for joining us today. We always want to encourage you with these kind of topics to make sure this isn't the last you ever discuss it, but this really is the beginning of the conversation. And if you need to take some action regarding workers' compensation, then there'll definitely be more questions, more research to do. Guide One is going to have some excellent resources for you, and you can contact us at ministrypacific.com as well. Justin and Brian, thank you so much for your time today. Thank you everyone for joining us, and have a wonderful rest of your week.